Following on from the last video where we looked at employer-employee relationships and the current legal framework, we're going to move on now to minimum wage rates. So at a national level, the minimum wages are determined by the Fair Work Commission. Again, emphasising the important role that the Fair Work Commission plays. They have a panel and they set the minimum wages for all workers as a baseline for the minimum rates of pay that workers must receive. And that minimum wage panel reviews the minimum wages annually, so every year, and it takes submissions from employees, from unions, from employers, and also the government. Minimum wages are set for each industry, and Australia, and just recently, about 2 months ago, they handed down their most recent update to the national minimum wage, and this minimum wage panel, decided that the minimum wage in Australia would increase by $22 a week to $694.90, so that's $694.90 for a 38-hour working week. And that represented a 3.3% increase on the hourly rate of pay, which went up to $18.29 an hour, or an increase of 59 cents an hour. So the Fair Work Commission plays an important role in determining that minimum wage, and then that minimum wage will flow through to all of the agreements and the minimum wages across all types of employment, and I should also say play an important part in the awards within each particular industry. The employment contract and within the current legal framework, an important element of that are the awards. They are now called modern awards, but generally just shortened to awards. And an award refers to the legally enforceable minimum terms and conditions that apply to a business or industry. So terms and conditions. It's not just about pay or the hourly rate of pay. It's about a lot of other things, i.e. hours of work, overtime rates, meal breaks, clothes washing allowances, for example. So there are 122 industry and occupation awards that cover most people working in Australia, as directed by the Fair Work Commission. Important to understand that before the Fair Work Act of 2009, there were some 1,200 different awards, because awards were state-based and federally based. But the Fair Work Act abolished all those state-based awards. They brought them all to a federal level, and we've gone from, I think, somewhere in the order of 1,200 different awards across the country to now just 122 federal awards, which cover all workers across the country. Important to understand that modern awards can be modified in some areas, for example, working hours, penalty rates, under the individual flexibility arrangements. So some of you may be thinking that, if we go back to the previous point about the minimum wages, well, your parents, for example, aren't getting paid $18.29 an hour, and that would be true in nearly all cases. That's because they are on their own individual flexibility arrangements, i.e. they have negotiated a higher rate of pay with their employer. Okay, so what is an enterprise agreement? A really important thing to understand from the context of the employment contract. An enterprise agreement is a collective agreement made at a workplace level between an employer and a group of employees about terms and conditions of employment. And it's usually for a single business. For example, Shaw School would be an example, and we are employed under an enterprise agreement, we being teachers. In the national system, enterprise agreements which alter the award conditions must pass a better off overall test, known as the BOOT, better off overall test, which means that employees must be better off under that enterprise agreement than under the relevant award, or it is not approved as valid by Fair Work Commission. So, for example, here at Shaw, we could be employed under the relevant award, and we would just accept the conditions of that particular award, the teacher's award, whatever the conditions of that award are. But the teachers here at Shaw are not employed under the award. We are employed under a Shaw enterprise agreement, which means that some of the conditions are better, and we are better off overall under that enterprise agreement, which relates specifically to this workplace, than the award on which that enterprise agreement is based. So, for example, those things which may be better off might include things like pay. It might include things like holidays, for example. So employers prefer an enterprise agreement system compared with the award system, because agreements can be tailored to suit each business. And on that point, why is it better for workers at shore, for example, to be on an enterprise agreement? Well, the award doesn't account for coaching sporting teams. It doesn't account for going on overseas trips with orchestras. It doesn't account for going to coach teams and turning up on a Saturday to coach for half of your day on a Saturday, for example. Therefore, it's relevant to strike your own enterprise agreement and to negotiate your own enterprise agreement to ensure that those elements that are unique to your workplace are factored into your agreement and that you're not just working off the award where those elements would not be considered. There are three types of enterprise agreements. Single enterprise agreement, made between a single employer and a group of employees at their workplace. Multi-enterprise agreements, made between two or more employers and groups of their employees. That could be single enterprise, would be Shaw and our employees. Multi-enterprise could be Shaw and Winona and their employees, for example. And greenfields agreements, single enterprise and multi-enterprise agreements relating to a genuine new enterprise of the employer or employers that are made before any employees to be covered by the agreement are employed. So that would be a new entity being established. So other employment contracts. Due to the ever-changing nature of work, there are increasing types of contracts, and they include individual common law contracts, independent contractors, contracts for casual work, and part-time contracts. The important one really is individual common law contracts. And this exists when an employer and an individual employee negotiate a contract covering pay and conditions. So again, coming back to the point that most of your families, for example, would not be being paid on the minimum wage, and a lot of them may not be getting paid under an enterprise agreement. They are on an individual an individual common law contract, a contract that has been negotiated between their employer and them, the employee. Importantly, however, the baseline for their contract is still the relevant award in their relevant industry, and that ensures that they are getting a higher rate of pay than the minimum wage under that particular award, and that their hours of work, etc., are not worse than the award. Common in the private sector, i.e. outside government, and for senior managers on salaries that are above $130,000 to have individual common law contracts. Often informal and provide less protection than other agreements to the employee, and that's an important point. When you go onto an individual common law contract, you give up a lot of the benefits that an enterprise agreement might give you, and it's up to you to negotiate some of those benefits to ensure you don't lose them. An individual common law contract does not have to be approved by the Fair Work Commission, but it is governed by the court system. So if you have a dispute, it may well end up in the court system. Another couple of employment contracts, independent contracts. People who say they're a freelance writer or they're a consultant, undertaking work for others. They may enter into an independent contract, i.e. a 3-month contract to undertake a certain amount of work. They do not have the same legal status as an employee, so they're giving up some of that right, generally for a higher rate of pay. It's very common in the construction industry, and the Fair Work Commission has clear criteria to determine a worker as a contractor, and they carry most of the risk on a job undertaken, including covering their own super, their tax, their insurances, and their annual leave. And this is why many employers prefer to rely on independent contractors, as it allows employment risks such as sickness to be shifted to the person undertaking the work. So putting someone on an independent contract means you don't have to pay them their super, you don't have to pay them sick leave, you don't have to pay them any annual leave as an employer. Casual work, contracts with employees for short-term, irregular or seasonal work, paid an hourly wage, they're not entitled to any paid leave. They're not entitled to sick leave, they're not entitled to long service leave, for example. Okay, I'll let you read that in your own time. Okay, next video will focus on work health and safety and workers' compensation.